folks, so what I am discussing today is domestic law and Article 10. So I'm going to talk about obscenity, defamation, Protection from Harassment Act and the Malicious Communications Act. So first of all, obscene publications. Well, what is obscenity? It is any item that is likely to deprave or corrupt the people seeing it, and that comes from Hicklin. For example, Lady Chatterley's Lover, the book was banned. The word deprave means morally bad. So the law is governed by the Obscene Publications Act 1959, and there's a second act 1964. So section 1 subsection 2 of the OPA 1959 says that obscene publications includes a wide range of media, so articles, reading things, looking at things, sound, film, pictures. Section 4 contains a defence to obscenity, so if it's in the interest of science, literature, art, learning or general interest. The 1964 Act restricted what you can publish even further. So it said that you cannot make financial gain from publishing obscene materials. Now, another offence that links to obscenity is outraging public decency. This is a common law offence. So this deals with material that is obscene or immoral. Case of Shaw, he published a ladies' directory which contained the details of prostitutes in London, and he was guilty of corrupting public morals. Gibson, freeze-dried fetus art display, again guilty of outraging public decency. Okay, the next thing to look at is defamation. What is defamation? It's when you I guess play you make a serious impact on a person's reputation, and there are two forms of defamation. You have libel, which is a permanent form because it's in writing, and then slander, which is a transient form because it's speaking. So if the claimant wants to prove defamation, first of all, the burden is upon them on the balance of probabilities, and the law is governed by the Defamation Act 2013. So our claimant has to prove that whatever was written or spoken caused or is likely to cause serious harm to their reputation. This could also be financial harm as well. They also have to prove that it is actually defamatory. An ordinary person would think worse of them. They have to prove that it identifies them and that it is published to a third party. Now, the person who publishes, either in writing or the person who says the potentially defamatory thing, has many defences to defamation. So truth, section 2 of the Defamation Act says that truth is a defence. Section 3 deals with an honest opinion. So if you honestly believed it to be true at the time, then that is a defence. Section 4 says that if it's a publication on a matter of public interest and that you've tried to verify the truth, and they consider them good sources, you can have a defence. There are also some internet defences like innocent dissemination and e-commerce regulations. And then finally, you have the defence of privilege. So if you say something in a police interview, you can't be sued for defamation. Judges in court cannot be sued for defamation of character. MPs in Parliament have absolute privilege and they can say what they want without fear of being sued for defamation of character. Now, more legislation that deals with these issues. Protection from Harassment Act 1997. This was introduced to deal with the problem of stalking, and it created two key offences. So pursuing a course of conduct amounting to harassment, conduct which puts the victim in fear of violence. So what is harassment? Well, it's when you alarm a person or you cause them distress. And a course of conduct, this can be speech, but it also involves activities like following somebody. And you have to do this on 2 or more occasions. So it is a criminal offence, but also the court could issue an injunction and that's a civil matter, so that you stay away from the person. And then finally, the Malicious Communications Act 1988. So it is an offence to send a person a letter or an electronic communication or article of any description that conveys an indecent message or something that's grossly offensive. It's also an offence if there is a threat and information is false or it's known to be false by the sender. Now, the mens rea of this crime is intent to cause distress or anxiety to the recipient or any other person. The case that I would use for the Malicious Communications Act is the case of Chambers, and this was a tweet about Nottingham Airport where he threatened to blow it up. He claimed it was a joke because it had 3 exclamation marks, but on appeal he was successful, but the magistrates convicted him because they said it was a grossly offensive and menacing message, but on appeal he won his appeal. So there's lots of legislation and some of it will overlap, so it's not strictly just for Article 10. So be aware of that you may see it in a variety of forms in a scenario question.